You're watching the Florida Channel a public service of the Florida Legislature, WFSUV, and Florida State University.
Please rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save the United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning. Welcome to this session of the Florida Supreme Court. The first case on our calendar today is Krauss versus Textron Financial Corporation. Are the parties ready? You may proceed.
Honorable Clerk. May it please the court, my name is William Donovan. I represent the petitioners Andrew Krauss and David Bausch. I live and practice in Naples. This is where the claim arose. With your permission, I would like to briefly recite what I think are some of the pertinent underlying facts and how this particular litigation got before this court. The issue had to do with my clients having purchased equity memberships in a country club in the Naples area. Now, I must tell you, not being a golfer, what I know about how this occurred is from what I've read. It was a contractual relationship between the two parties. Twin Eagles was the country club. My clients, of course, purchased the equity memberships. And from what I can determine, the real key to an equity membership is that at a later date, should a member decide to resign from the club, that member is able to then have his membership resold to somebody on a waiting list. And the resigning member would be entitled to, in this case, it was 90% of whatever the sales proceeds were at the time. And I believe the proceeds at the time that these two gentlemen resigned were in the area of $100,000 to $110,000. So 90% of that would have been their property. What occurred, however, is that in 1999, when they resigned, their memberships were sold to new parties, but instead of the funds being delivered to my clients per the contractual documents, they were delivered to Textron Corporation. Textron.
Now, in connection with that, could you address the relationship between your clients and Textron? You assert that there was a confidential relationship. Is that correct?
There's an allegation in the complaint that there was a confidential relationship. I don't see that, to be candid with you. The confidential relationship that I see is certainly between Twin Eagles and my client.
Okay, so you're conceding that there was there are in fact no ultimate facts that are alleged that would support the existence of a confidential relationship between your clients and Textron.
There was no contractual relationship between the two parties.
So the only relationship really Textron has is with, they gave a loan to the country club?
Yes.
Are those memberships in any way intertwined with that financing as you construct and build a country club? You sell memberships, and are there any issues with regard to the financing being related to the sale of those memberships and then the proceeds,
yes.
What happens to them?
Yes.
So it's intertwined with that.
Well, it is to that extent, yes. The question was whether or not there was a confidential relationship.
I understood the question.
Okay.
I didn't have the same question.
I understand, and I appreciate your point. Definitely, it was intertwined. The question, and we challenge that Textron even had any security interest in the sale of my client's memberships.
But was it claimed?
Pardon me?
Was it claimed? Did Textron say they had an interest?
Yes.
So they said they had an interest in
well,
this?
They not only did they say they had an interest in it, they had the funds delivered directly.
Well, we understand that. We really we read the briefs.
Okay.
So we understand all the facts. And I mean, really what you're getting into is the question of the relatedness or the connexity of all of these parties and how the statute, you really need to get to that because you're running out of time pretty quickly,
right.
The tolling statute and whether this claim that's filed in bankruptcy, how the statute applies in that context, that's where you really need to be going here.
Yes, sir. I appreciate that. Thank you. Just to lay the predicate to answer that question, this involved an appeal, a claim that was filed in bankruptcy, an adversarial complaint, and you read the allegations of it. It was, summary judgment was granted on the merits, solicited by Textron. The court exercised its jurisdiction, granted summary judgment on the merits, and there was an attempt to appeal. And therein is where things went awry, and how he ended up before this court after the case was ultimately dismissed.
But the party in bankruptcy was the country club, correct?
Twin Eagles, the country club.
And so why was a complaint filed in bankruptcy against Textron, since you say there really was an contractual relationship between your clients and Textron? So why file a complaint in the bankruptcy proceeding against Textron?
Because it is our position that Textron was not entitled to the particular funds that were delivered to Textron by Twin Eagles, that those funds were the property of the petitioners.
But how do you get those funds back in a bankruptcy proceeding against Twin Eagles?
Against Twin Eagles?
Yeah, the bankruptcy proceeding was about Twin Eagles.
Right.
So how do you get money back from Textron? That's what you were trying to do, correct? So how do you get that money back in this bankruptcy proceeding?
I'm sorry. By virtue of the adversary complaint that was filed, an attempt to state claims for unjust enrichment as well as a constructive trust.
Well, at what point had the monies that you claim your clients were due transferred or paid over to Textron? Was it before the bankruptcy proceeding was filed or during the pendency of the bankruptcy proceeding? In other words,
both. The allegations of the complaint in the circuit court allege that the funds that were given to Textron at the May of 2009.
No, in other words, when you filed your adversarial proceeding in the bankruptcy case.
Yes.
At that point, were the funds already in the hands of Textron?
Yes.
So, and how soon after that initial complaint, your complaint was filed, did Textron move for summary judgment on the basis that there was no basis for the bankruptcy court to adjudicate this claim?
About 2 years.
See, the issue that we're struggling with is that you've obviously asserted a claim in bankruptcy. The argument on the other side is that there really was never a basis for a bankruptcy court to take jurisdiction over that adversarial complaint, never from the beginning. And so we're interpreting not really what the bankruptcy court had as far as jurisdiction, but what the meaning of in D 367D is, that it's for any claim asserted under subsection A shall be told while the claim is pending. If you never had a proper claim pending, the argument on the other side is it never is told. So that's what we got to deal with. We've got to get to that question for us.
Well, and I appreciate that. The answer, in my estimation, is that the exercise of jurisdiction by the bankruptcy court was just that. It was at the behest of Textron. They took advantage of that. They obtained a summary judgment on the merits.
What merits? On the merits of whether there was jurisdiction?
No. It was on the merits of the claim that we filed, the constructive trust issue, whether or not we could prevail. That was the issue that was before the bankruptcy court.
But the district court did otherwise.
The district court, yes. The district court made an entirely different finding at a later date subsequent to, and this is the important part, the dismissal of Textron with prejudice by my clients in the adversary proceeding. Suddenly, at that point, jurisdiction was never a question. It was never raised by Textron. It was never an issue. The court exercised jurisdiction on the merits. It wasn't until after the voluntary dismissal with prejudice against the bankrupt debtor that the issue of lack of subject matter jurisdiction was raised, and that was in 2005. This thing had been pending for a number of years, and in 2005 there was a dismissal, and that is what triggered the allegation that there was no subject matter jurisdiction, because if you don't have a bankrupt debtor in the proceeding, no matter what occurs as between Textron and my clients, it's not going to affect the bankrupt estate.
Really, from a practical standpoint, if there's not tolling, we're going to really need the practicing lawyer is going to have to file in two places, right? They're going to have to file in bankruptcy court and in state court.
Yes. Yes.
As you look at this, I understood from looking at the materials that what you were not aware at the time the action was filed in the bankruptcy court, that the money had been turned over to Textron. Is that incorrect?
Yes.
That's incorrect.
No, I'm sorry. That is probably correct. The allegations of the original complaint indicated that the country club used it in their.
So if there is, and I'm trying to understand this. It seems to me, and you probably know more about the bankruptcy proceedings than I do, but it seems to me that if I'm sitting there and there is someone files for bankruptcy and I've given them money, and there have been transfers from that organization to other people, that there may be some preferential transfers that are set aside in bankruptcy. Is that a possibility?
Well, that is a possibility.
And payments that are made to people, maybe not as to Textron, but I mean, isn't that where this is sifted out? That if a bankrupt submits hundreds of thousands of dollars to someone and then files for bankruptcy, don't the bankruptcy courts look at those transfers if someone asks them to determine if it's some kind of preferential transfer?
Yes, Your Honor.
And wouldn't this money be in that kind of category?
Well, I mean, that's the allegation of the adversarial complaint.
Okay, so now we're there to that point. Then the question becomes, is if it's later determined that that was not factually correct or whatever, does that then cause the tolling provision to not apply? That if you have to go back to state court, you may be out. That's what this case is really about.
Well, I understand. When you say that it is not factually correct, can you be more specific?
Well, no, what I'm saying is that if your allegations are that this is some kind of preferential transfer, that money really belongs to you, yet the bankruptcy court says no, that's not the case, rules against you, does that cause you to lose the rights under the tolling statute because the court's determined that it doesn't have jurisdiction to give that money back to you that belongs to someone else?
It should not. It should not.
Okay, well, that's the question that's before us. Why not?
Well,
what's the law in the area?
Well, the law, I think there are two Florida cases that are extremely important. One of which is the Scarfo case, which has been discussed, but probably equally important is the Blinn case, which was first DCA. And both of those cases, they were not bankruptcy cases, so I'm not going to be able to cite to you a Florida case that's on all fours in terms of bankruptcy. But I am citing to you cases which I believe are on all fours in terms of federal jurisdiction, federal causes of action. And that's the case. If you take a look at Blinn, it was a situation where a federal cause of action was asserted in federal court along with a state cause of action. And the plaintiff in that case, Blinn, decided to voluntarily dismiss and reassert the claims in state court. When they were reasserted, the statute of limitations had already run. It was dismissed at the state level on the statute, taken up on appeal. And the issue in that case was precisely the issue that's being raised before this court. The issue was whether or not 1367D only applied to those cases and claims where the claim was asserted under 1367A through C, found by the court to be related, but with a discretionary decision not to exercise jurisdiction.
But jurisdiction was not an issue in Bliss.
I'm sorry?
The bankruptcy court's jurisdiction was not an issue in Bliss. Am I correct?
Well, in Blinn, there was never a decision.
Blinn, I'm sorry.
There was never a decision concerning jurisdiction.
Right. But in this case, in your case, it was dismissed from bankruptcy court because the bankruptcy court didn't have jurisdiction to begin with.
Well, I mean, that is stated in the final order.
So the gist of your argument then is anytime someone files a bankruptcy proceedings, whether the bankruptcy court has jurisdiction or not, that automatically stays the state court action.
Yes.
Well, no,
just by virtue of the fact that you filed a claim in bankruptcy court, whether there's jurisdiction or not?
Well, I mean, there has to be some relationship between the bankruptcy proceeding and the claim that's filed. It has to be taken on a case-by-case basis, and I don't think we're going to be able to find any facts of this particular case that are extraordinary or unusual that on their face, as pled, would clearly take it out of the bankruptcy proceeding. There are only two ways, as I understand it, to challenge jurisdiction. One is on the face of the complaint. If it is clear that there's no jurisdiction in the court, well, then the court can dismiss it upon proper motion. The other is a factual finding, and by definition, one has to look to the facts of the case, which is what was done in this particular situation.
So you're saying it has to be a colorable claim in the bankruptcy proceeding?
Yes, Your Honor.
So it can't be something that has no relationship whatsoever, just a specious sort of claim.
Right. Right. I mean, I think that's a reasonable interpretation. Now, having said that, the Supreme Court has commented in the Raygor case, which I believe was Minnesota Board of Regents. Now, frankly, it was dicta, but they did comment that the language is so broad that it could be dismissed for any reason. So that is within your authority to rule that, should you so choose.
Well, and I know you're in rebuttal, but really what we're doing here is construing a federal statute.
Yes.
And trying to determine if that federal statute is broad enough so that a claim asserted shall be told to really probably effectuate the purpose, which is that if someone's filing what would be also a potential state court claim, but it could be alleged to be related to the pending full claim, that again, as Justice Paulson said earlier, a litigant shouldn't have to be figuring out, I better file in both places and protect myself, and by filing in state court, they should be able to rely on the statute. And so you're alleging or asserting a very broad interpretation of that statute.
Yes, and I wish you were here at the podium making that. It's very well put. I mean, that's exactly what we're saying. We have a situation where it really was a catch-22 for us. No matter where we asserted it, we were subject to being jerked into bankruptcy as being related to. We asserted it in bankruptcy. We're subject
but that didn't happen. I mean, and ultimately the district court determined you weren't related to. I mean, and that's kind of a binding determination between the parties here, isn't it?
Well, that's the language that was used. I mean, I can't dispute what language is in the case, but you have to consider how it got there, because the motion to dismiss the appeal after the voluntary dismissal of Textron said very specifically, this court does not now have jurisdiction because of the dismissal. Anything that's done as between Textron and my client's not going to affect the bankruptcy estate, which was true, but that occurred in 2005. Now, that did get extrapolated into some language saying that there was never any jurisdiction. But it's not a logical finding, and I certainly don't agree with it.
Isn't it clear that early on when the payments were made from TCG to Textron, that your clients filed an action in state court regarding the transfer of the money?
My understanding is that, no. My understanding is that there was an action filed by Mr. Bausch.
Okay.
Prior.
In state court.
And when bankruptcy, against Twin Eagles alone, and when bankruptcy was instituted, then that matter was removed into the federal court. And, of course, both Bausch and Krauss being creditors.
Dismissed or stayed?
Pardon?
Dismissed or stayed?
Stayed.
Okay.
Stayed and then ultimately dismissed. But Textron was not a party to that. Okay. Right. So that has no real bearing. I mean, it's pretty typical in terms of how these things occur.
You're well into your rebuttal, if you would like to save any time, Mr. Donovan.
Well, I have, 50 seconds before I'm finished, and then I have 5 minutes?
No, that's...
I'll save 47 seconds.
All right. Thank you.
Good morning. May it please the Court. Justice Kennedy, you asked if there was a relationship between Textron and petitioners. The answer is there was none. Not only is there no confidential relationship, there's no relationship whatsoever. The relationship was between Textron and the debtors as lender and borrower, and between the golf club and the petitioners as golf club and members.
Was this at least a colorable claim?
No, it was not, Your Honor, because the funds at issue, and it's undisputed in the record, were transferred to Textron prior to the bankruptcy case, and that is the basis for the federal district court's conclusion holding that there was no subject matter or related to jurisdiction in the bankruptcy court. The funds were transferred pre-bankruptcy.
Would you help me with this? I mean, I understood, and I've seen it happen, where someone files for bankruptcy, and there are challenges to payments that bankrupt has made, and the bankruptcy will reach out and pull those back in.
Your Honor.
And it has to be certain allegations, preferential payment or something like that. Does that happen?
Your Honor, that does happen, but that is inappropriate here as a matter of federal bankruptcy law because Textron was a fully secured creditor, and fully secured creditors in bankruptcy cannot, as a matter of law, receive preferential payments.
Okay. So even if these people, let's make this assumption that this loan was secured by these memberships.
It was secured by all of the assets of the debtor. It was a blanket.
Memberships.
Yes, sir.
Okay. And in some fashion, one of the memberships or the value, the money for the membership comes in question. You're saying that under no circumstances could a member who says that's my property could trace that or could go against Textron, who has that money, clearly related to the membership, and there's just no way that can happen.
That could not happen here on the facts before this court because the funds were transferred pre-bankruptcy. If you look at the federal district court's decision, it explicitly held that because the funds were transferred pre-bankruptcy, they lost their character as property of the estate. The second DCA, in its opinion, said that petitioner's failure to appeal that ruling was outcome determinative.
Now, your position is that if a bankruptcy or if a federal court, I assume, bankruptcy is part of the federal court system.
Yes, sir.
And the statute applies to the federal court system, correct?
Well, in my brief, in a footnote, I identified that the case law is split on whether bankruptcy courts even have the power to exercise supplemental jurisdiction. I will represent, Your Honor, that I am unaware of controlling case law from the Supreme Court or the 11th Circuit that says one way or the other. But I'm just telling you,
I understand.
The case law is split.
I read your brief.
Okay.
I understand.
All right.
I understand. But you did a fine job in pointing these out.
Thank you, sir.
But the question we're coming down to is that it seems to me the fundamental principle. Are you saying that if a federal court, whether it's let's assume it's not bankruptcy, a federal court makes a determination that claimant has no claim, that as a matter of law eliminates application of the tolling statute?
No, what I'm saying, Your Honor, is that because there was no subject matter jurisdiction related to subject matter jurisdiction in the bankruptcy court, then there couldn't be any original jurisdiction in subsection A.
So you are saying then, as far as subject matter, if a federal court refuses to take jurisdiction and says we don't have jurisdiction, then that eliminates applicability of the tolling section.
Exactly, of D, because
I just
subsection...
have a hard time understanding that because it seems to me that the statute, the tolling statute, is precisely for that purpose, and that if it's dismissed, it allows the merits of the claim to be decided and not pushed aside on a procedural maneuver.
It's not a procedural maneuver, Judge. Can I briefly give Your Honor some context?
Of
this
course.
lawsuit started in state court, and contrary to my opposing counsel's understanding, my understanding is that both petitioners sued against both respondents. In footnote 1 of the initial jurisdictional brief filed by petitioners in this case, they said that upon the bankruptcy filing, the state court lost jurisdiction. That is simply wrong as a matter of federal bankruptcy law. The automatic stay has no application whatsoever to Textron. It wasn't a defendant.
But to the bankrupt, it does.
It does, but
right.
Your Honor, I'm going to answer your question. I promise I'm going to answer your question. But I have to make clear, there was absolutely nothing about the bankruptcy filing that required the dismissal of the state suit against Textron and to bring him to federal court. They could have continued prosecuting the state court claim.
May not have been anything that prohibited it, but initially, if there is a colorable claim, a good faith claim made that Textron somehow has assets that belong to that they obtained through the bankrupt, that belong to the claimant, they can't make that claim through bankrupt.
I didn't say they couldn't.
I'm saying can they, and that's the point. Because one is maybe it's not a valid claim, so it then comes down to that you have to have, if you have an adjudication that the federal court's not going to hear this claim. If that eliminates the tolling statute, then it seems to me there's no reason for a tolling statute.
Sir, there was an absence of subject matter jurisdiction here, and this is important for bankruptcy purpose. The determination of what property does or doesn't constitute property of the bankrupt estate is made at the petition date. Prior to the petition date, the funds were transferred. The claim should have been asserted in state court, and they should have kept. I'm sorry, Your Honor.
Go ahead.
They should have maintained prosecuting the state claim in state court. There was no reason for them to come into federal court.
So they made an error as to where their lawyer made an error, presumably good faith, to file as a related claim in bankruptcy. What year was that claim? What year did they file? Did they dismiss, I assume without prejudice, their state court claim and then refile the claim in bankruptcy?
It's my understanding, Your Honor, that the initial state court lawsuit was filed in June of '99.
Okay, and when was the bankruptcy initiated?
I believe it was early 2000, but I'm not positive.
2000.
It was after the bankruptcy proceeding
Had begun.
They dismissed the state court suit.
Textron immediately moved to dismiss for lack of subject matter jurisdiction?
We moved for summary judgment.
And in what year was that?
In 2000, Your Honor.
In 2000?
I believe so.
And you moved for summary judgment rather than motion to dismiss for lack of subject matter jurisdiction?
That is correct, Your Honor.
Well, so my question is, if this is all so clear, and there couldn't be a colorable claim, why wouldn't Textron have moved to dismiss for lack of subject matter jurisdiction immediately after this claim having been filed? Why would they move for summary judgment on the merits of the claim itself? That is, whether there could be unjust enrichment or constructive trust.
Your Honor, it's a fair point. We probably should have moved on that basis originally, but as Your Honor knows, subject matter jurisdiction can be raised at any point in the proceedings.
I understand that. I'm just, again, going and really
looking.
I mean, there's the tolling statute, the federal tolling statute, again, seems to have some equitable purposes so that a plaintiff who is filing a case is not lost in terms of a statute of limitations.
I don't disagree with Your Honor,
and Textron had notice. I mean, a lot of times, the whole issue of statute of limitations, make sure you're on notice of the claim, so that you were on notice of the claim. Certainly was filed in state court, and then when it was refiled in federal court. So why isn't the better part of interpreting this statute to interpret it broadly to allow that it be told while the issue of whether there is jurisdiction or whether the claim has merit is pending in federal court?
Because the statute 1367A requires original jurisdiction, and that was lacking in this case. That's why.
Let me ask you a couple of questions. The first is, you said that it's not a colorable claim because the payment had been made to the creditor pre-bankruptcy. Right?
Your Honor, I didn't say it was not a colorable claim. I said there was no jurisdiction of the bankruptcy court to decide it. It was between two non-debtors and the property, because the property was transferred.
I misunderstood that, because the first question was, is it a colorable claim? And you said no, and I thought the answer was because the payment's already been made to the creditor.
Well, it's not colorable to Justice Lewis's question about whether it could be a preferential transfer, and as I explained.
Really, the question is, the debtor would not really be in a position to know whether those payments have been made to the creditor, would they?
I can't speak for the debtor. I don't know what we represented. Obviously, Textron, the secured creditor. We had a creditor-debtor relationship.
That's not something they would typically know what was done with the funds.
I think they were just paying monies down. And in the affidavit, in Mr. Lee's affidavit, he said that Textron had no knowledge that the funds they received in part were derived from the proceeds of the sale of the petitioner's golf memberships.
Okay, let me ask you this.
Yes, sir.
I think you were, in an exchange of answering questions a while ago, you were making a point about the debtor had filed a state court action, right?
No, sir.
No.
The petitioners filed a state court action against Textron and the debtor, Twin Eagles.
Right.
Okay? And what happened was, subsequently, the Twin Eagles and its affiliates filed their bankruptcy cases. Then the petitioners dismissed the suit and brought it into federal court. In footnote of their initial jurisdictional brief filed with this court, they said the bankruptcy filing caused the state court to lose jurisdiction. I'm explaining that that's fundamentally wrong. under federal bankruptcy law. They could have kept, there was nothing about the bankruptcy filing that prohibited the petitioners from continuing their lawsuit against Textron. Nothing. It was not a debtor.
So they voluntarily dismissed that
Correct.
suit and should not have.
Right, and that goes contrary to counsel's statement about being jerked into federal bankruptcy court. Textron didn't remove it under the removal statute to federal court. They voluntarily made a strategic litigation.
Well, but the debtor did. It did stop it as to the debtor. It did stop it as to the debtor, didn't it?
Subject to a modification of the automatic stay.
Exactly.
Correct. As to the debtor, but not Textron.
I understand.
Okay.
What is the interrelationship between that fact that they dismissed a state court action but should not have and the interpretation of this federal tolling statute?
The nexus, Your Honor, is that this isn't the typical case where you start in federal court and then go back to state court. They started in state court, and there was no basis or need for them to move to federal court. And that goes to what I suggest is the apropos and apt reference to the voluntary but improvident foray into the federal arena language that was quoted by the 2nd DCA from the decision by the 4th DCA in Heckman. This was a voluntary matter. Textron did not drag these people into federal court.
Is there some kind of waiver with their voluntary dismissal of that state court action? There's no waiver, is there?
I don't know there's a waiver. I'm suggesting that it supports, it gives context to, and supports the decision of the 2nd DCA. That's what I'm suggesting, Your Honor.
Let me ask this. Can an action lie in bankruptcy court against a creditor if the allegation is being made that a transfer from the debtor to the creditor, even made before the bankruptcy petition is filed, was done in contemplation of bankruptcy?
It could be, and that goes to Justice Lewis's question about whether it could be a preferential payment, and that's Section 547 of the Bankruptcy Code. But again, that would not stand here because Textron was a fully secured creditor. And
so you can never have a transfer in contemplation of bankruptcy to a secured creditor. Is that what you're saying?
You could have a transfer, but it couldn't be avoided as a preference because they're a fully secured creditor.
But wouldn't the converse be true? Had the golf course paid Krauss and Bosch, that would have been a preferential payment, would it not?
It could have been. It could have been.
But it was never money owned by, I understood the allegations, this money always belonged to, 90% of it belonged to the people. It was not the money of the golf course, only 10% was.
I don't disagree with that, sir.
Well, I don't understand your last answer then.
I'm not sure I follow the question. The money, they were due the monies, but again, it had been transferred pre-bankruptcy. It wasn't property of the estate any longer, and that's why they should have kept continuing their lawsuit in state court instead of bringing it to the federal arena. And I want,
but because there is this whole notion that you can at least allege that this was made in contemplation of bankruptcy, I'm not sure why this wouldn't in fact then be a colorable claim that was in fact somewhat related to the bankruptcy petition.
I don't know that it wouldn't be a colorable claim. I'm just telling you, as a matter of substance, it would fail. As a matter of law, secured creditors cannot receive preferences. In putting aside the issue of...
So why, well then just answer this. Why in fact did the bankruptcy court then try to adjudicate this situation?
Frank Runner, I think we all missed the issue of the lack of subject matter jurisdiction. But what the district court said in its opinion is that the money was transferred pre-bankruptcy, it lost its character as property of the state. The 2nd DCA noted that petitioners failed to appeal that ruling. It was outcome determinative. But there's another reason why that there was a lack of subject matter jurisdiction, which again goes to the inapplicability of 1367, which requires original jurisdiction. In petitioner's brief, they posit a circumstance where the petitioners would have been successful against Textron. Textron would have paid them X dollars, whatever X was that they were owed, and that therefore the amount of Textron's claim would have increased in the bankruptcy case, and that would have had a conceivable effect and therefore satisfied the related to subject matter jurisdictional grant. But what petitioners failed to do was do the second half of the equation. as Textron's claim in their scenario would have increased, the petitioner's claim against the estate would have decreased proportionally, dollar for dollar. It would have been a revenue-neutral transaction, so there would be no effect on the estate. And that's what the PACOR test says. Can there be a conceivable effect on the estate to give the bankruptcy court subject matter jurisdiction? And there could be none as a factual matter. Forget about the legal matter and their failure to appeal the district court's ruling.
But do you know that as you go in? How does a claimant know that? You don't know that until you start lining up assets and debts.
Well, no, it does apply here, Your Honor, because...
I didn't say it doesn't apply. I said, how do you know at the outset? How does a claimant know at the outset? You can't know until you add them up and balance them.
I respectfully disagree, Your Honor.
How can
But the bankruptcy court didn't know, obviously, because they dismissed it.
I understand. I'm responding to the situation counsel posited in his papers as to why there was related to jurisdiction. I'm suggesting as a factual matter it's impossible. If they had been successful, any claim of Textron would have been reduced, but their claim, increased, and their claim would have been reduced because they would have been paid. They couldn't get a double recovery. So there was no effect on the bankruptcy estate.
I'm still troubled with what in the world we even have this tolling provision for if it is as you described. If I go into the bankruptcy court and I file the claim and it's a good and valid claim, it stays there and it's litigated. However, if I go into the bankruptcy claim, and I don't need to toll because it's going to be litigated, but if I go into the bankruptcy court, any federal court, and it's dismissed, it seems to me that that's what the statute is for. If you are dismissed in the federal court system, that it comes back. I mean, it's nonsensical to have the statute if it never applies.
Your Honor's question respectfully presumes that there's subject matter jurisdiction, and there was none in this case. And again, I'm relying on the statute, subsection A. It explicitly requires original jurisdiction. It was lacking in this case. And if there's no original jurisdiction...
What you're saying is that it's the adjudication of that. What if the interpretation is that you file it as within their original jurisdiction, but you're wrong, and it's dismissed?
But, Your Honor, the issue here is property of the estate. It's determined at the petition date. So... If
it is within the subject matter jurisdiction of a bankruptcy court or a federal court, do they keep it litigated?
No, they're not supposed to. They're supposed to dismiss. It was never within the bankruptcy court's jurisdiction.
No, if you will assume with me for a moment,
yes, sir,
that whatever the claim is within the subject matter jurisdiction of that bankruptcy court or federal court.
Yes,
and assume that with me, and then that court then keeps the case, the action, and adjudicates it. Correct?
Correct. In that situation, I would agree.
And so you don't need the tolling statute for anything, do you? Because you've already adjudicated it in the bankruptcy, in the federal system. Correct?
Correct.
And so the only time you need it is if the federal court is not going to act on the action that's been filed there.
But on non-subject matter jurisdictional grounds. That's the difference.
Okay. Well, I hear your argument.
Okay.
I hear your argument.
But isn't that what Scarfo discusses in there? The federal court determined that they did not have subject matter jurisdiction.
That is correct.
And it wasn't appealed. And in the Scarfo opinion, it stated that that the tolling statute applied because it was only after the determination as to whether or not there was subject matter jurisdiction that the case was dismissed, and that you needed. So that's why you have the tolling until whatever is at issue, that is whether you're going to accept jurisdiction or you don't have jurisdiction, is determined. It's tolled for that period so that somebody isn't caught in a situation where they're trying to litigate in two different forums.
I understand, Your Honor, 2 points. First, Scarfo is factually distinguishable. There was a trial on the merits of whether the defendants were employers for Title VII purposes. After that decision was made, it was appealed, it was affirmed. Then there was a dismissal, not subject matter jurisdiction grounds, but because the plaintiffs couldn't state a claim against the defendants. That's what distinguishes that case from this case. This case was dismissed on subject matter jurisdiction grounds. And to the statement made by the court there, which I see you're reading the opinion, they said that they disagree that a dismissal on subject matter jurisdictional grounds makes the tolling provisions of 1367D inapplicable. And I'm suggesting to Your Honor that respectfully that decision, that statement, which is dictum, incorrect because it disregards the requirement in subsection A of 1367 that there be original jurisdiction. It was lacking. Here it's lacking, and there wasn't.
And with that, you have exceeded your time. Thank you very much for your argument.
Thank you, Your Honor.
You have a minute or so for rebuttal.
Do you agree that you could have continued your claim against Textron in state court at the time that the Twin Eagles filed for bankruptcy?
There simply was no claim against Textron existing in the state court. There was a claim filed against Twin Eagles by Mr. Bausch. That is it. And
So we just have to look at the record. You're saying that what he said, which is that both petitioners filed a claim against both Textron and Twin Eagles, is not correct?
That's incorrect. And the record will not contain this information. I mean, we could send you the complaint from the circuit court, which I have, to show you, but that's a misstatement of the facts. I disagree with his characterization of SCARFO. SCARFO clearly, by its very terms, both at the federal level and at the state level, turned on the issue of subject matter jurisdiction. There was a finding that the federal court did not have subject matter jurisdiction because, very simply, there was a requirement of at least 15 employees, and that threshold requirement was not met. Ergo, there's no subject matter jurisdiction. Nevertheless, when the matter was when there was a summary judgment granted and the state claims were dismissed, they were refiled within the 30 days, and the SCARFO court said very simply, lack of subject matter jurisdiction doesn't make any difference. These claims were filed, they were filed timely, and they're entitled to the tolling.
Well, I guess the distinction they're making is at least Judge Farmer says that there had to be a resolution of the factual dispute before it was dismissed. And what what Respondent's Counsel is saying is here there was no factual dispute. It never could have been related to the bankruptcy case.
Right. He would like to argue that, but it's hard to overlook the fact that nothing occurred with regard to jurisdiction until after the bankrupt debtor was dismissed by prior counsel. That was a triggering event. Any other questions?
And thank you also for your arguments here today. Thank both of you.
Okay, thank you for your courtesy.
The next case on the court's agenda is Gomez versus City of Pinecrest. Mr. Diaz.
Your Honor, please, good morning. Richard Diaz, counsel for the petitioner, Zenaida Gomez, who's present in the lavender suit in the gallery of the court. The concise summary of the facts are as follows. In October of 2007, Zenaida Gomez, a resident of Miami-Dade County, Florida, owned a private rental residence which she attempted to rent out to an individual, a third party, which she successfully...
I think we understand the facts.
Yes.
Isn't the issue here one purely of statutory construction?
Agreed.
And the issue is whether in the first stage, that is the seizure stage, whether if the municipality or governmental entity established probable cause that the property was used in a criminal enterprise, whether that is sufficient to allow for the seizure, and then knowledge of the owner is something that is then litigated in the second phase. And the question is really whether the statute passed by the legislature intended to do that. And isn't it pretty clear on the face of the statute that that's exactly what the statute provides?
That is exactly the issue, and I do not believe that the statute on its face clearly does not require owner knowledge.
Well, let me ask you this question. Most of your brief is devoted to whether the statute as applied would be an unconstitutional violation of due process. It sounded to me in reading the briefs that the issue that knowledge did not appear in the statute was conceded, and you were arguing an unconstitutional application. Is that the thrust of your argument?
The thrust of our argument is that the statute should be construed to require owner knowledge at the adversarial preliminary hearing because failure to do so constitutes a due process violation, which is there's no opportunity to be heard.
Okay, now that is what this seemed like you were arguing that. When was that argument? That is that it would be a due process violation under the Florida or federal Constitution. Was that made in the trial court?
No, the argument made at the trial court. We argued the Carr decision at the trial court.
The who decision?
The Carr decision. The only decision.
Venice?
The Lexus case, 2001 first
okay,
DCA
all right.
case.
And then was at the appellate level at the 3rd District, was a constitutional argument made?
It wasn't made in a precise constitutional context.
Well, I mean, it's a pretty easy thing to say, Morrissey or Venice requires this. We looked at the briefs. Does not seem that was an issue at all.
What's the underlying concept behind notice and opportunity to be heard?
But the Venice, you didn't argue. Was there an opportunity to discuss Venice? And Venice didn't even require knowledge at the second stage.
Venice was not argued in the briefs or in the.
Well, isn't that the most applicable due process case?
It is.
Well, but isn't it the case that your initial brief in the 3rd District does not contain the words due process?
Correct, and I conceded that. It wasn't. We did not argue constitutional due process in the 3rd District.
So are you now saying that for you to prevail here, we would have to read something into the statute that right now does not exist as far as knowledge?
No, what I'm saying is what this court, in taking this case up on review, what this court, I believe, is doing is looking at the split in the circuits or the districts. The 3rd, which has ruled that no owner knowledge need be established at the APH, versus the 1st and now the 5th.
Well, I understand why we have conflict jurisdiction. I'm trying to understand how, in reading this statute, that you can come up with any other conclusion that when the legislature amended the statute, they placed the burden to prove knowledge on the state at the forfeiture stage, and that knowledge at the seizure stage was not something that they were required to establish, and that if they wrongfully seized something that ultimately was found to be that you were an innocent owner, then there are provisions for damages, attorney's fees. So everything about the statute seems to contemplate that the seizing agency does so at its risk, that is, that they could be found liable for damages, but in that 10-day or whenever it is adversarial preliminary hearing, that knowledge isn't required. Now, I might say I don't like that statute. I think the legislature, that was a bad statute for them to pass. They require notice at both stages. But I'm not the legislature.
I understand. And let me tell you where exactly in the statute we read that owner knowledge should be considered. And I want to reflect the 5th District Court of Opinion in Brevard versus Baggett to that case. In Section 932, 703, 2C as in Charlie, it says, and I quote, when an adversarial preliminary hearing is had, the court shall review the verified affidavit. I'll stop there to say that what we're talking about there is generally the police report that the officer swears to under oath. And it continues, and any other supporting documents. In this case, what we had were the photographs of the hydroponics operation in the garage. But then it says, and take any testimony to determine whether there is probable cause and take any
probable cause to believe the property was used, is being used, was attempted being used, or was intended to be used in violation of the Florida Contraband Forfeiture Act.
And take any testimony presumes that in some of these cases, a claimant will come forward and demand an APH, as Ms. Gomez did in this case. She will appear at the hearing and not assert a Fifth Amendment right, as she did in this case. And she will testify, and the court will take testimony. If, as a Fifth DCA said, when a claimant asks for an APH, and when that claimant testifies that they had no knowledge, the court must consider that in the probable cause determination. And that is what we're saying, and that's the reading of the statute that doesn't necessarily require owner knowledge across the board.
But aren't you reading out of the statute when you say that? The very language that Justice Periente just continued with about, and take any other testimony that is basically pertinent to the issue of probable cause. And the issue of probable cause has to do with whether or not this property was being used to facilitate a crime. That's the probable cause issue before the court, isn't it?
It is, but if the owner's testimony, and take any testimony, is irrelevant to the determination of probable cause, the Florida legislature would not have... Well, the
owner's testimony then, it seems to me, would only have to go to whether or not the property was really being used to facilitate the crime. That's what the owner can come in even at the seizure stage and say, no, this property was not being used to facilitate a crime somehow.
Except that you also have further language in that same provision of the statute which says was used, was attempted to be used, or was intended to be used. And the real question is used by whom? Whose use, which means knowledge, because if you're using a house to do something illegal, you have the knowledge. Whose use are we talking about? Are we talking about use by the owner or use by the tenant in a tenancy, landlord-tenant situation as we had here?
But you're adding, by saying that, is to me that you're adding something into the statute that's not in the statute. All the statute really requires is that someone have used the property to facilitate the crime or intend to, one or the other of those three disjunctive factors.
Well, one of the problems, and this is the dissent from Judge Shepard in the third DCA, and I tend to agree with him, that he says is that we have to read the forfeiture statute because forfeitures are harsh extractions. We have to read the forfeiture statute in the whole, and we have to construe it narrowly in favor of or against forfeiture. And one of the things that Judge Shepard said in his dissent was that the forfeiture proceeding, a forfeit case, it's really not a two-stage process. It is one process that has probable cause, and then it has a final adjudication on the merits. And what we argued in the third DCA is that 932-7031C is that very, very harsh extraction. The Florida Forfeiture and Contraband Act has a very unique provision, unlike in the federal system in many other states. And that is that as soon as the probable cause order is entered, you lose your property in the state of Florida. You are divested of ownership.
You lose an immediate possession of the property. But
ownership, respectfully, ownership. It's one thing if you kick me out of my house. It's another thing if you don't let me tell you that I'm innocent and you take away my house.
And where is the term ownership?
It says, all rights to, interest in, and title to contraband articles, in this case it would be the residence, used in violation of 932-702, shall immediately vest in the seizing law enforcement agency upon seizure, not forfeiture. So what this statute says and what this statute does is it allows, as in this case, a law enforcement officer to go to someone's residence on a legitimate police call, determine that it's a contraband article, say, get out of here. The owner shows up in court 10 days later, waives his or her Fifth Amendment rights, is told, as in this case by Judge Hubbard, we're not going to listen to you. You are not to be heard. And we're going to take away your house.
Well, explain, what do you think is the purpose of the two steps? What's the purpose of the seizure portion of the forfeiture statute?
I think the purpose of the seizure section is for the seizing agency, if probable cause is determined, is to be able to take control of the property. But the
so that the property will no longer be used for illegal purposes, probably.
Correct. And that can be accomplished by the police simply removing the hydroponics equipment, putting a Liz pendants on the property, and then going to the next step if that's where we're going to go. If you apply this statute strictly on its terms, here's what could happen. This is exactly what could happen. I can go and rent a room at the Ritz-Carlton Hotel. I can engage in criminal activity that is subject, makes my conduct come up with under the Florida Contraband and Forfeiture Act. I pay my nightly rental. The police come into the room. Brevard County Sheriff's Office, Monroe County Sheriff's Office says, we're going to own the hotel. The hotel owners come in and say, wait, we're here at this adversarial preliminary hearing. We had no way of knowing that one of our guests was going to do this. And the statute says, for now you lose. For now you lose, we own it, and we'll talk to you 1 or 2 or 3 years down the road. That's the practical effect and application of the court. That's exactly what this statute
does. Now, this 1-2 year thing that you're talking about, let's talk about the actual second stage, which says that property may not be forfeited unless the seizing agency establishes by a preponderance of the evidence that the owner knew or should have known that the property was being employed. Now, that's as clear as it could be as to what's required at the second stage.
Well, there's a second part, too, but yes. The second part is they also have to show by clear and convincing evidence that the article was used in violation of the statute.
So even a higher burden on clear and convincing evidence.
In the second stage.
So you're talking about 1, 2, or 3 years. Doesn't it have to be scheduled within 45 days?
The adversarial preliminary hearing, well.
I mean, you can't ask a judge to say, Judge, my client has no notice, no knowledge. I request that there be an expedited hearing on this second stage so they can be put to their test of proving, since they have to prove it, I don't have to say a thing. Are you saying judges won't expedite that if there's an issue being raised about knowledge?
With the absolute deepest respect to this court, I've been practicing in Miami, Florida for 22 years. You cannot ask for an expedited trial in Dade County today and get a trial in a civil case in less than 1 year,
So isn't that the issue? So there's an issue, maybe a problem with the rules as far as getting things scheduled, but as far as the actual language of the statute, I'm still having a hard time understanding that forfeitures are disfavored, that a seizure provision that has no requirement of knowledge is now we would have to rewrite the statute to put that in.
I don't think the statute has to be rewritten. I think the court simply has to recognize the infirmity of the statute and read into the statute an owner knowledge requirement if it's a little.
Now, when you say infirmity, now you're going back to the constitutional infirmity?
It's not necessarily constitutional. It is the fact that you can take somebody's property away from them at an APH with probable cause, and we don't listen to the innocent owner at the APH. We simply ignore them and take away their property at the same time.
If we agree with you and the owner put on evidence, what is whose burden and what is the standard of proof that has to be that the judge would adjudicate? Where do we come up with that one?
Well, in Carr, the first District Court of Appeals came up with the language of basis for belief that the person knew or should have known. The Fifth District Court of Appeals in the Baggett case rejected that and said, no, we're going to go with probable cause to believe that the owner knew or should have known. Those are the two standards that the First and the Fifth have established in those.
And you're saying only if the owner waives the Fifth Amendment right and tries to offer testimony would this occur?
Right, exactly. And that's why I think that Baggett is a little more narrow.
So we're just playing around with the words to try to figure out the standard and the burdens.
It's not a question of playing around with words. It's a question of
it isn't playing around with words. It's actually writing in provisions that don't exist.
It's not writing in a provision. It's giving meaning, breadth and meaning to a statute that otherwise lets a seizing agency take somebody's property 10 days after it's seized, especially in a rental situation where you're not even at the property, take it away from that person and hold it. And when that person comes in and tries to make a claim that affects the probable cause determination, you say, we are not going to listen.
So in essence, your argument is that this should be a one-step process. Instead of a seizure process and a forfeiture process, it all should be one at the preliminary hearing, the seizure and forfeiture aspects should be taken care of then and there?
Well, I don't think practically you can do that because we have discovery issues and trial preparations and things like that. But I do think that
because then you're absolutely right. The state in 10 days probably doesn't have enough information to determine whether or not the owner is an innocent owner or not.
Understood. But again, that is why what I'm saying is it doesn't have to be one procedure proceeding, but what's going to happen practically is there's a seizure notice, it goes out, and more times than not, these folks do not have innocent owner status. They don't even have standing. In those cases, there's no problem with a probable cause finding. In fact, the statute even says that where nobody files a claim for an AEH, the judge gets the complaint and enters probable cause. It's a unilateral, it's an academic or ministerial act. That's one thing. And a person can't be heard to complain later on that their property has been taken if they haven't made a claim and they don't have standing. What I'm saying is that what this court should follow is and resolve the conflict in favor of the Baggett decision, because Baggett said when, and it's narrower than a broad application, when a claimant has standing and comes in at the APH and says innocent owner status, you have to then use that to determine the probable cause determination.
I'd like to clarify whether you have abandoned your argument that the statute is unconstitutional.
I wouldn't say that I've abandoned it. Our position is...
So you're still contending that the statute is unconstitutional?
The application of the statute, where a person has standing and goes to an APH and waives their Fifth Amendment right and asserts innocent owner status... How do you square
that with Bennis versus Michigan, the U.S. Supreme Court decision that came down in 1996?
Because in this particular Florida state forfeiture statute, unlike many other state statutes and certainly the federal forfeiture statute, you lose your property immediately. It's a big difference from a statute that says we're going to take possession and control over it, we have the occupancy agreement, you can stay there, and then we'll decide who owns it 1 or 2 years down the road.
What's that got to do with Bennis?
I'm sorry?
What does that have to do with Bennis versus Michigan?
I'm not certain.
You familiar with Bennis versus Michigan?
Yes.
I don't understand how the distinction you're drawing has anything to do with the rationale that was expressed there. But you're running out of time here.
Okay.
Well, let me ask you on the point you're making about seize, you lose ownership, not possession, right?
Yes, sir.
So then, when the forfeiture aspect occurs, how does the title get affected then? How does ownership get affected?
Here's what happens. When the case is tried by jury and can only, if there's a claimant, there's a jury trial normally unless they waive it, or there's a default. In either case, there's a final judgment of forfeiture. Once that final judgment of forfeiture is entered, that has to go to the title vest in the sheriff's or the seizing agency's name at that point in time. And then the property goes up on an auction block and gets sold. And eventually, there is a final judgment of forfeiture, which legally vests title in the seizing agency's name, and the seizing agency then either deeds or it goes through the seizing agency's name to the buyer at the auction.
Well, how does the title then pass at the seizure stage, not when the final judgment is entered?
It really doesn't per se, in the sense that there's not, if you look at the chain of title, you won't see a deed in the name of the seizing agency. What you have is a lis pendens and a recorded probable cause order. And if you're a title agent, you study title, you simply look at the statute that it refers to and it says title vests in this company. It's by operation of the probable cause finding in the APH order itself. But there's no real estate instrument, if that's what you're asking, that form that we use.
So they can't go and sell the property before there's the forfeiture.
They can't go and sell it, but they own it. And that's when we get into all these practical problems with maintenance, et cetera, that I mentioned in my brief.
Would the same thing be true on personal property as far as title?
Yes, the statute that I referred to doesn't distinguish between real or personal property.
So it's not like if it's a vehicle, say, they can't go in and actually sell the title with the property until the forfeiture proceedings.
They can, and this is the way it happens. Either by stipulation of the parties, or they can motion the court because that's a depreciating asset, and they have an interlocutory sale, If the judge determines that that's the better way to preserve the asset from declining, depreciating, and accumulating storage charges, then that is done by court order. The courts have
challenged, they cannot.
They cannot. Okay, thank you.
Thank you.
May it please the court, counsel for petitioner. Good morning. My name is Cynthia Everett, and I'm the village attorney for the village of Pinecrest. The village of Pinecrest is not seeking to abandon or hide from any of its burdens in this matter. The statute clearly sets forth a two-stage process for forfeiture proceeding: the adversarial preliminary hearing stage and the second final forfeiture stage. And the plain and clear reading and language of this statute only provides that at that first stage, that the seizing agency's only burden, only responsibility is to show or prove probable cause.
So what would be the innocent owner's role at the preliminary hearing? I mean, an innocent owner such as Ms. Gomez, who's not even on the premises, what would be the point of having a preliminary adversarial hearing at her request if she can't come in and say she's the innocent owner?
If, under the facts of this case, there was only one claimant or person entitled to notice, and the probable cause is as clear as it was in this case, frankly, there would not be any real point to having that adversarial preliminary hearing, because, again, that's just to establish probable cause for the continued seizure of the property. But as is in this case, there's more than one claimant here, more than one owner, or more than one entity with an interest in this property.
Who are the others?
There's a mortgage holder. And that person
who requested the adversarial preliminary hearing?
Well, Ms. Gomez wanted the adversarial preliminary hearing, but again, as was mentioned by this court, at that hearing, you can challenge probable cause. There may be reasons in other types of cases where probable cause can be established and can be defeated at the adversarial preliminary hearing stage, regardless of your knowledge as an owner. In thinking particularly about this case, in almost any scenario, I can't imagine a case where the owner's knowledge or lack thereof is going to impact on probable cause, which is solely focused on the property. The fact that in this particular case there is a residence being used as a marijuana grow house in Pinecrest, whether Ms. Gomez or anybody else claims we didn't know about it, does not in any way change or mitigate the fact that that property was clearly being used to facilitate a crime. That's probable cause.
But you're going to have to prove eventually that the owner knew that the property was being used, or had reason to know with reasonable care, whatever the language is, to know that the property was being used for that illicit purpose, aren't you?
Absolutely.
All right. Now, suppose, for example, that the owner in this case moved to Europe, got a job in England for 5 years, lives in England, and rented the house gave it to an agent to rent the house to whoever was willing to lease it. How is it that you're going to prove, how is that not a part of probable cause? The fact that she had absolutely no knowledge, wasn't living in the country, no way of knowing.
That is not probable cause, because the fact that she turned the property owner to one person or another does not change how that property was being used, regardless of who the person was who was using the property in that manner.
But part of probable cause is the fact that she knew it was being used for that purpose.
Most respectfully, we disagree with that. That tends to be the language and the ruling with the First and the Fifth DCA courts, but that is not, owner knowledge is not a part of probable cause. Probable cause is about the property. How is this property being used? How is this property acquired? How is this property being used to facilitate a criminal transaction? Owner knowledge frankly, is not likely in any scenario to play a role in that determination.
What does the language that your opposing counsel relies on about taking evidence? What does that mean?
If we're talking about 703(6)(a), no, that's the ultimate forfeiture.
I think
2C.
It was 2C.
To determine whether there is probable cause to believe that the property was used, et cetera, et cetera. And the court can take any testimony on that issue. On that issue, this property, maybe it's a duplex. Maybe the police mistakenly were observing matters from afar and focused on the right side of the duplex when it should have been the left side of the duplex. There could be situations where they got this boat mixed up with that boat. It wasn't this property that was being used, or it wasn't this property that was acquired with proceeds of a drug transaction.
So it can only be, under that phrase, evidence with regard to the property, not persons.
Well, I think the court will take, and in this case, we kept hearing that the court did not hear Ms. Gomez. Ms. Gomez testified at the adversarial preliminary hearing. The court heard her. The court took her testimony. So whatever testimony a claimant or a person who's entitled to notice may want to give is going to be done by the court.
But if it falls on deaf ears and doesn't have anything to do with the case, then it's a nothing. So I want to make sure I understand is that that's their argument, is that this is the clause that it comes into evidence on. So most times we're dealing with probable cause is it involves somebody doing something, and it does involve a person, not necessarily just property. This is one of those unique circumstances, and it is somewhat troubling the way that this is worded. I mean, that may be the outcome, but it is somewhat troubling. We have language like this in a statute, and in this country, that someone in total good faith. I mean, the priest has moved to Europe and loses his home. That's what's some troubling. And you may be correct, but I'm trying to understand. So it's only under that phrase is that it can only be things with regard to the property or what's happening there, nothing else.
Well, no, I want to make it clear. I think any testimony that a person wishes to proffer is going to be heard or at least listened to.
But not with regard to knowledge of what's going on there.
No, I disagree with that in the sense that if there is a scenario where knowledge may impact on a determination of probable cause, I think that testimony is relevant and will be taken. But in this scenario, whether or not you were on the scene or knew that your tenant or someone else was growing marijuana in your house does not change whether or not that property was being used to facilitate a crime. If you knew about it, the property was being used in that manner. If you didn't know about it, the property is still being used in that manner.
A couple of questions. Before this statute was amended, what the courts had interpreted the statute as to allow for the innocent owner defense, that is, for the person to be able to raise as an affirmative defense in the forfeiture stage innocent owner. So this statute actually shifted the burden to the state or the seizing agency to establish that element. So in effect, it made it strengthened, as I see it, the protection by putting the state or the seizing agency to that burden as an element of the forfeiture. Is that correct?
Yes, that's correct.
Had the statute ever been interpreted that at the seizing stage that knowledge was a part of the seizing stage?
Not until the first DCA, to the best of my knowledge.
So they really, again, when they went to this two-step process, as I said, they really put something on the state that had not been put on there before. Is that correct?
When the legislature changed the statute,
right.
Yes.
Okay, the other question I have, because one of the compelling arguments that is being made, it's sort of more of this idea of the state or municipality taking something. There is the priest, innocent owner, and it's not till 3 years later that finally, or she finally, I guess he, if it's a priest, finally is able to have their day in court and there's no evidence of knowledge. As a practical matter, or as the statute says, it
says that once the court determines there's probable cause to believe that the property has been or is being used, so again, they reiterate that's the finding, that the property is being used, the court shall order the property restrained by the least restrictive means. So I'd like to know, doesn't that sort of counter what counsel has been saying, which is that the court is charged with seeing that if there's a concern, again, if they've heard that this person might be innocent owner, that they order a seizure, but only in the least restrictive means so that the property doesn't continue to be used in a criminal manner. So can you address subsection D as being a way that these list of horribles are minimized, first of all?
Yes, Your Honor, I can, and I think Your Honor points to that section of the statute clearly. The property is clear to be held by the least restrictive means. It's important to note that in this case, it's a house, but it wasn't lived in by the owner. It was the owner testified at the adversarial preliminary hearing that this was investment property. So this is not a case where the Village of Pinecrest has gone in and put someone out of their home. Secondly, yes, the property is to be held by the least restrictive means possible. In this case, all the Village of Pinecrest has done is file a notice of lis pendens. That's it. And with all due respect to petitioner, I've been practicing law in Miami-Dade County for 27 years. Not only can you get an expedited hearing if you ask for one, you can approach the court at any time for any additional relief you might deem appropriate or necessary in this case.
So what has actually happened to this property? Is it just sitting there?
It's just sitting there and being maintained by the Village of Pinecrest.
Is it leased? Does the village then lease?
The village has not leased the property.
Well, so this also creates a problem if there's a mortgage on property, and there in City Beautiful with these McMansions and these 1 acre estates, kids smoke pot out behind someplace at the far edges of the property. Some plants grow from seeds and those kinds of things. I mean, theoretically, this thing could operate. Yes, that's improper use. You've got plants growing there, and you're going to lose your property if you don't pay the mortgage payment. So, I mean, it just seems like this is some kind of, a magical kind of thing. It's not a problem. I've had rental property, and if you depend on it for debt service, I mean, it has an impact.
It could have an impact, but again, if you have not exercised your ability or authority to go to court and say, I need a particular type of relief, I need to lease out this property, or someone needs to lease out this property so that the debt service can be made. If that's not done, then perhaps that is not a real consideration.
In other words, what you're saying is that the court has the flexibility to not only make sure the property is maintained, but that if there's but to take steps to ameliorate or mitigate any damage. Because ultimately, as I see it, if you've wrongfully seized this property, the city is responsible for the damages. Is that correct? So you've done this at your own. Basically, this is if eventually they find that you can't establish that Ms. Gomez knew or should have known, you got a bill to pay.
We may well have a big.
I mean, you agree that that's what's contemplated. That it's contemplated that the playing field is leveled by really contemplating that the state or the seizing agency is doing this seizure at their own risk.
And, yes, Your Honor, and it's our position that the statute has built in, it's replete with those types of provisions to protect the innocent, property owner, and to ensure that there is due process all along the way.
So why couldn't the innocent owner come in even at the I know that the focus of the preliminary hearing is on whether or not the property is being used to facilitate a crime. But as an adjunct to that, why couldn't you then have some testimony about the fact that this is rental property? I need to have a renter be able to re-rent this property so that I can make my debt service and all of that.
You could have that, and in this case, we did have some of that testimony. Here's the problem, I think, with that line of reasoning or taking it to its logical conclusion that all of this is resolved at this first stage. Forfeitures happen in various ways. I think The most common method or type of action is where there's probably a motor vehicle and something's being done inside that, with that motor vehicle, or is there a traffic stop, and then you find drugs or money. Or there's some type of investigation that's being carried out by law enforcement agencies. This was a fortuitous forfeiture. The Pinecrest Police, and that's conceded by the petitioner, they get a call that there's a problem at this house. There's an emergency situation, a burglary, someone's breaking in. They respond to the house. They check it out as they're allowed to do under law, and they find a marijuana grow house. So this is not an instance where we've had weeks, months, years to investigate and pull all our facts together before we go to the court with our evidence. Under our forfeiture laws, you are talking about probably no longer than 30 to 35 days with the statutory requirements of notice and 10 days, where you're in court asking for a full-scale hearing, almost a trial. It is not reasonable to expect a law enforcement agency to be able to, frankly, initiate and complete an investigation in that short period to counter any advocacy of innocent owner knowledge. And again, it can be more than one person coming in at that stage.
But wouldn't the way to solve some of this, because I keep on thinking of this situation of a year or two, couldn't the rules be amended to provide that if an owner asserts in a good faith basis for lack of knowledge, that any hearing not only is expedited but shall be held in could we do that without violating the statute to make that clear? I don't know, no one's really proposed that, but I just keep on thinking of the situation where you really do have an innocent owner, and here we still haven't gotten an adjudication on the merits, which I'm not sure I understand exactly why, but they could have proceeded with the second stage, it would seem to me, by now.
And I would like to address that because I'm hearing this 1 to 2 years or 3 years as a practical matter, and it's only going to take 2 to 3 years when you have a series of appeals, as we've had in this case. That's why we're 2 years out. And yes, the underlying forfeiture could have proceeded, but in light of the way the appeals were coming and being handled and the issues,
either the third district or this court could have allowed there is no reason that they couldn't have relinquished jurisdiction to allow the forfeiture proceeding to proceed.
No, that's correct. They could have, but it was a matter of economy when the parties asked the court to stay the underlying forfeiture. So normally, what I'm suggesting to the court, a normal forfeiture does not take 2 or 3 years. These matters are resolved on more than likely in less than a year. So anyone who's being
prior to the adjudication of any criminal action. Because sometimes criminal cases can take a while.
Sometimes criminal they do proceed on different tracks. So yes, I would say in most instances in state forfeiture proceedings, they are resolved prior to and independent of any underlying or parallel criminal proceeding.
If the state discovers, after they start discovery, that this is truly an innocent owner, I mean, their other remedy is to dismiss the action.
Dismiss the action.
So we really, in a lot of this, we're relying on the good faith of the state or the municipality to ensure that at any stage they find bona fide evidence that the person really did not know or should have known, that they ought to do everything to ensure that that property is returned.
Yes, the good faith of any party, and particularly in here the seizing agency is involved, but as a practical matter, there's a hammer over the seizing agency's head. The seizing agency may well be liable for any loss or diminution in value of the property, as well as attorney's fees and costs. So no reasonable agency is going to proceed and go forward or drag anything out if there's a real possibility that they're not going to prevail. But that's the purpose of allowing the agency time to seize the property, hold the property, and in terms of the concern, again, title is not perfected. The seizing agency cannot dispose of the property, sell it, use it, except to the extent that it may be necessary to maintain the value in terms of a motor vehicle that needs to be run or operated now and then. We can't do anything with the property.
Do they ever, if again, you're saying that a owner could go in and say, I found another renter, this is the renter, I'd like the approval that this be the person renting this property, can go back to the court and ask for that relief?
Frankly, I don't even think you have to go back to the court. You can talk to the Village of Pinecrest and say, this is what I want to do or I need to do, and the Village of Pinecrest can enter into that agreement.
But subsection
G... be determined by whether or not this is a crime scene that's sort of still a part of the parallel track criminal case?
You're correct if that is the issue, but I'm saying in terms of simplicity, approach the Village of Pinecrest and say, this is what I need. If the parties can't resolve it or work it out, it may require judicial intervention to fashion a different remedy in order to allow the use of the property if that's necessary, as opposed to a complete restraint or prevention of the owner of.
The point is that subsection D actually requires the court to only restrain the property by the least restrictive means.
And in this case, as I said previously, there's only a lis pendens on the property. Nothing else has been done to restrain the use of the property. I was just going to say, if there are no further questions, the Village of Pinecrest will stand on its brief, and we would ask you to affirm the decision of the 3rd District Court of Appeal. Thank you.
Thank you. I thank you both for your arguments here today. The court will now take its morning recess for 10 minutes.
Ladies and gentlemen, the Florida Supreme Court. Please be seated.
The last case on the court's agenda for today is Mendenhall versus State. Are the parties ready?
Yes, Your Honor.
You may proceed.
May it please the court, I'm Megan Collins, and I represent the petitioner Charles Mendenhall. I ask to reserve 5 minutes for rebuttal. Mr. Mendenhall was convicted of attempted second-degree murder and was sentenced pursuant to 1020 life to 35 years in prison with a 35-year minimum sentence. On a 3800B2 motion, the trial court reversed this sentence and resentenced him to 30 years with a 25-year minimum sentence, finding under Yasin and Collazo that is the maximum sentence permitted when a defendant is convicted of attempted second-degree murder with a firearm with a discharge causing great bodily harm or death. The state cross-appealed, and the 5th District Court of Appeal remanded for the imposition of the original sentence, holding that under 1020 life, the mandatory minimum provisions inflate the statutory maximums under 775.082.
So the first thing that happened is, as you say, he was found guilty of a lesser included offense of attempted second-degree murder with a firearm, correct?
Yes, Your Honor.
That would have been a second-degree felony.
Yes.
That would have given him, with that 1020 life, a 15-year sentence. Is that correct? So the first part that happened is that under 1020 life, it was reclassified from a second-degree felony to a first-degree felony, and you do not take issue. That was permissible. So
Yes, Your Honor.
his sentence, which would have been a maximum of 15, is under, with 1020 life and the 787 period statutes goes to a first-degree felony.
Yes, a statutory maximum of 30 now.
Are you saying, the first argument would be that those two statutes have to be read together. That is 1020 life, I'm trying to find the statute.
775.082.
082, right. That those have to be read together.
Yes, Your Honor, they have to be read in parliamentary.
You're agreeing that as it affects the mandatory minimum, that the mandatory minimum in the 1020 life has to control the lower part of the sentence.
I would argue that the mandatory minimum is subject to restrictions by the statutory maximum.
So that in this case, though, the mandatory minimum is, which would not exist if you just look at 775.087, is 25 years.
Yes, Your Honor.
Okay. Now, isn't the argument, though, that the state is making and that the 5th District agreed to is that the clear language of 087 requires that if the person upon conviction for discharge of a firearm shall be sentenced to a minimum term of imprisonment of not less than 25 years and not more than a term of imprisonment of life, that means that any felony with a discharge of a firearm could be sentenced to a maximum of life in prison.
That is the position that is taking now in Mendenhall. That wasn't their position originally in Yasin and Brown. In those two cases, they correctly held that the maximum sentence that could be received would be 30 years in prison. I argue that the legislative intent is that the statutory maximum limits the mandatory minimum under 1020 life. The legislature has specifically included in the 1020 life statute 775.0872 to address potential conflicts with other sentencing statutes. It explicitly recognized that minimum sentences under 1020 life are subject to the statutory maximums in 775.082, 775.084, and under the Criminal Punishment Code. And then I would argue that clearly the legislature intended that there be a limitation on the mandatory minimum sentence, and they did not intend for the mandatory minimum sentences to inflate to the maximum of life for every affected felony.
They could otherwise have said, it would be very easy for them to have said that, which is that in the event of any conflict between what the statutory maximums are under 775.082 and this, that this is meant to override any other statutory maximums. Is that correct?
That's clear.
Just like they did for statutory minimums.
Right. That is what they could have done, and they chose not to. And instead they said that a mandatory minimum exceeds the maximum sentence authorized under those three provisions, then the mandatory minimum sentence must be imposed. I would argue.
So how? I understand what those statutes say. My problem is this: that how do we know what the mandatory minimum is in this case? Because it is a range, because it goes from 25 years to life. So why isn't it appropriate to say that in this case you could have a mandatory minimum of up to life without violating these principles, even though the statutory maximum is 30 years? Because if the mandatory, you would agree that the legislative intent is that the mandatory minimum should apply if it is the greater of the two sentences.
Yes, Your Honor.
Okay, and so why isn't the greater of the two sentences in this situation life even? So certainly 30 or 35 years would be in the range between 25 and life.
Well, Your Honor, when they drafted the statute, they specifically said if the minimum mandatory exceeds, then the mandatory minimum would apply. And I argue that by using two different terms within this provision, they are actually describing two different things. The minimum mandatory refers to the range of sentencing permissible under 1020 life minimum sentencing, and mandatory minimum refers to the least that must be imposed. It was clear that the legislature intends that there be mandatory time served, and I would argue that their intention by drafting it this way was that you serve 25 years, the mandatory minimum, if your statutory maximum is less than the range of years.
In what situation would it be that life could be imposed where it couldn't be, well, wouldn't that make it, the 25 to life, have no effect? Because in what situation, if the judge already didn't have discretion to impose life, then isn't that provision meaningless?
I don't believe the provision is meaningless. Yes, if the judge didn't already have discretion, he could not impose life. However, it was giving the judges the discretion to not give a mandatory minimum sentence that would be based on how the judge views the case, if they were going to give the defendant life and only a mandatory minimum term of a less year. Now, at the moment, that would have no effect because a life sentence is life. But it would be a possibility in the future that the judge could show some mercy towards a defendant.
Well, give me a situation where the range would have meaning as far as a judge imposing a harsher sentence than they could have or the judge could have under the present law.
Well, in Collazo, the defendant was convicted of third-degree murder, which cannot be reclassified under the circumstances of that case. So it was a second-degree felony. So he ended up with a sentence of 25 years of DOC time with a 25-year mandatory minimum because his statutory maximum was less than the minimum mandatory. So the minimum mandatory was imposed, which does have the effect of increasing the statutory maximum up to the point where the minimum sentence is imposed.
No, I'm asking you, though, where the 25 years to life would have effect, up to life.
I don't have an example of that.
Because there isn't one, right?
There is not.
Well, does that mean you're just kind of reading words out of the statute here?
I'm not sure I understand the question.
Well, help me understand what the legislature meant when it said in 775.087.2A3, the provision that deals with circumstances where there has been a death or great bodily harm, that the trial court shall sentence the person, or the person convicted shall be sentenced to a minimum term of imprisonment of not less than 25 years, nor more than a term of imprisonment of life in prison. What does that range? What's that about? What are they trying to get at there?
I think the range was reflecting the fact that there will be several felonies with different degree levels that will come into play, and it was to give the judge discretion to deal with the situation.
Well, let's see, a first-degree felony, is the maximum sentence always 30 years, or is there any scenario when the maximum sentence for a first-degree felony is more than 30 years?
Well, there's first-degree felony punishable by life.
But then you already have the life, and right. So, are there any I thought there were some felonies where the maximum sentence was 40 years. No?
I don't believe so, Your Honor.
You see where we're having some trouble here is you would never get, under 1020 life, a life sentence.
Unless you already
for
could
any
have
crime,
received life.
because 25 years would always, under your scenario, be the maximum mandatory that they could get.
Provided that the range was not enhanced but up to 30 years. But yes, Your Honor, you're correct that they could not get life.
Could they, under this original sentence, they imposed a 35-year sentence with a 35 mandatory minimum. The amended sentence was 30 years with a mandatory minimum of 25. Is there any reason the judge, even under your scenario, couldn't have imposed a sentence of 30 years with a mandatory minimum of 30 years?
Well, Your Honor, the case law supports that 25 years is the maximum that he could receive as a minimum mandatory sentence. But I believe that the statutes could be construed to say that the statutory maximum will act as a cap. The minimum sentence could be 25 up to the statutory maximum.
I mean, that to me, I see no reason that it couldn't at least change so that he's serving the entire sentence of 30 years.
That's a far less tortured interpretation of the statute, yes, that he could serve the range from 25 to 30, and that the statutory maximum would simply act as a cap on it. But I would argue, Your Honor, the legislative intent is clear that they never intended to inflate this to statutory
Well, it's
maximum.
not clear. The question is, I mean, to me, it's not clear. I think when 1020 life was promoted, I would have thought that, and I guess we thought it enough in the case that our dicta suggested that someone got life. But I think there's, the best argument you can make is there's an ambiguity because, as I said earlier, it seems like there would have been an easy way, rather than just referencing these other statutes, to say this scheme takes precedent and overrides any statutory maximum in 775082 series of crimes.
Yes,
correct?
It's clear.
And there would be no reason that they'd even need to reclassify these from second to first, because you can impose up to life anyway.
Yes, it's clear that if the legislature's intent was to inflate the statutory max, they could have done it very easily.
Isn't there some language, and there's so many sentencing statutes these days, but I thought there was some language in these statutes that talk about it's the legislative intent that you can get, that a person should get the maximum that they could possibly get.
Well, it has been said several times in the 1020 Life Act that they are intending to punish to the harshest extent of the law. Mm-hmm. At the same time, the legislature chose to draft this as minimum mandatory sentence, and the whereas clauses in the 1020 Life Act specifically say that they intend for minimum mandatory sentences to be imposed. The legislature, on one hand, is saying they want harsh punishment, but then they are saying and defining, by making this minimum mandatory, exactly how harsh these punishments are to be. Which is why I would argue under the rule of lenity that the statute should be interpreted so that the maximum sentence for the defendant is 30 years with a 25 to 30 minimum mandatory sentence.
So your argument hinges at least in part on the distinction between minimum mandatory and mandatory minimum.
That's one argument I'm raising, Your Honor.
Help me understand again what that distinction is.
Since the legislature has chosen to use two different terms within the same sentence to give meaning to the legislature's intent, the argument is that minimum mandatory refers to the minimum sentence under 1020 Life, which is not less than 25 years and not more than life. When they later refer to the mandatory minimum sentence being imposed, I argue that that means the least sentence that must be imposed, the mandatory sentence, which would have been 25 years, which must at least be imposed under this statute. However, as Justice Parienti pointed out, a more reasonable interpretation of this statute would be to argue that the statutory cap of 30 years is applied and the minimum mandatory sentence is the range from 25 to 30.
Because what you would say is under C, if they meant something else, they should have said if the minimum mandatory exceeds the maximum sentences, then the judge has discretion to impose up to
the statutory, up to life.
Up to life. I mean, that would be the, rather than talk about a mandatory minimum, which is always seen as the floor.
Right. But they chose not to do so. Thank you. No further questions?
Thank you.
Good morning. I'm Assistant Attorney General Mary Jolly from Daytona Beach, representing the state of Florida. Let's direct this court's attention to the actual sentencing provision here. It provides for a term when you discharge a firearm and cause death or great bodily harm in 17 enumerated offenses. In those instances, the language of the statute in subsection C3 is they will be sentenced to a minimum term of imprisonment of not less than 25 years and not more than a term of imprisonment in life. It creates a sentencing range. And this sentencing range is being nullified by the argument that it's now capped at 30 years. That interpretation defies the plain language of that provision.
Except then you go to C. I would be with you if we stopped there. But I was surprised when I read this subsection C to look at what the language was that the legislature used. I mean, it would have been so simple for them to say it is the intent of, if that the court shall disregard the maximum sentences authorized by 775082, 775084, and shall sentence based on the statutory minimums and maximums set forth in the statute. Then you'd have, that would be the end of the story. But instead, they use this term that if the minimum mandatory sentence imposed exceeds the maximum sentence, then the mandatory minimum must be imposed. Now, that certainly means that in the situation, say this hadn't been reclassified, it was 15 years, but the mandatory minimum is 25 years, then you would impose the 25-year sentence. And no one disagrees with that one, right? If the maximum is less than the statutory, if the statutory maximum is less than the mandatory minimum. My problem is when it's not less. I don't see where the legislature has clearly authorized that the sentence be imposed be one up to life.
Let me answer that twofold. I disagree that the minimum mandatory is not 25 years when you cause death and great bodily harm and discharge a firearm and commit these enumerated felonies. The minimum mandatory is a minimum term of 25 years up to life. So the 35-year sentence with a minimum mandatory is permissible under the plain language of that sentencing range they've provided under these unique factual circumstances which the state has to charge and prove. I think and I tried to explain this in my brief, it's unique in the instance where there's discharge, great bodily harm, or death when it becomes 25 to life. I think when you apply that provision, if there had been no great bodily harm and the defendant discharged the firearm, it would be a 20-year minimum mandatory sentence, and it could go up to 30 years. It reconciles there. It also reconciles had he just possessed. So I think the uniqueness comes only in these circumstances, but the plain language provides for a term. It's a unique area where the trial judge is actually given back some sentencing discretion to work with a sentence in between the 25 to life term as provided under that provision.
But it would say, but using the term then, the mandatory minimum sentence must be imposed.
Mm-hmm.
If that suggests one number, as you say, it works well in the two other subsections. There's to me, a questionable application when it's a range. I mean, I understand, again, whether the legislature intended it or not, it just seems like would be such an easy fix for them to fix this and say this overrides the statutory maximums and these other provisions.
I think if you look at subsection D, I think the legislative intent is clear that we're going to punish to the fullest extent of the law. I mean, this court in McDonald, I think, did a really nice job of demonstrating how this is a very specific sentencing provision over the more general provisions relating to PRR, but I would submit to the court, and again, a more general sentencing provision under 7752, which classifies those offenses. This is a specific sentencing scheme that dominates over the more general provision, and I think when you have, look, this is the plain range. We want 25 years is a minimum mandatory, up to including life for these instances, these most violent crimes where death or great bodily harm ensue. And then with the intent of the legislature, which has been overwhelming, the preamble clause, I've not seen many that have that much of intent, that gun-wielding people that use these guns and commit these serious crimes are subject to 25 to life. I think if you read them in conjunction with subsection D, I think the unambiguous construction is that it's a minimum term of 25 years that can go up to a minimum term of life. If not, to construe it otherwise would nullify this provision where the stated legislative intent has been cleared. It's a specific sentencing scheme. And I urge this court to look at its analysis of that specific versus general that we did in McDonald when we looked at it in comparison to the PRR statute, and said it was more specific to that because it presents a unique sentence scheme for unique serious crimes. So we have the plain language of it's 25 to life as a minimum mandatory under these instances, and provided legislative intent. I've looked at these sentencing schemes, and this has a specific subsection providing what the intent would be. And I think the 5th District Court of Appeal, comfortable with that, applied the plain language and ruled correctly. The DCA's construction to limit it to a 25-year minimum mandatory is illogical when you read the plain language of the statute.
I guess in some sense it's logical because we get into this whole double enhancement in this statute, because you not only have already reclassified it from, he was convicted of a second-degree felony.
Attempted
now
second-degree.
he's actually convicted of a first-degree felony, and then on top of that, you're going to add in, this other. So I could see the logic in wanting to in the appellant's argument.
I understand that concern, Justice Quince, but I do think that this is a specific sentencing provision that narrow itself to these limited facts. It's not just you can get life. I mean, all of these things have to fall into place. The prosecutor charged it properly here. There's special verdict forms, and then at that juncture, it springs it. So it's not nullifying or eradicating the reclassification provision under subsection A. It's creating a more specific sentencing scheme for these particular offenses, and that erodes my concern. It may not erode George's, but I think that we have to look at it in terms of what this legislation was about. And we remember, and I remember the commercials, the posters, and the bumper stickers, 10, 20 life, and the legislative intent, and it is a specific sentencing scheme that applies in these most violent, narrow crimes.
So what guides the discretion of the judge if the judge, again, I think the appellant conceded that the mandatory minimum could be 30 years, not 25 years. I think that is clearly contemplated, not in conflict. But what guides then whether here somebody who is found guilty of the lesser offense of attempted second-degree murder will get life in prison by the trial judge, and I assume that the judge could say with a mandatory minimum of 75 years. What else comes into play in how that judge decides between whether they're going to give 25 years, because they could still do that, or they're going to give life?
Again, I think, Justice Periente, the uniqueness of it gives sentencing judge some discretion based upon the facts of this case.
But that's a pretty big range. That is essentially, let's assume that 25 years up to life with nothing for the discharge of the firearm. Again, when I read those posters, I assumed it was a mandatory life if you discharged a firearm, and you're agreeing that the judge is the one that has discretion as to where from 25 years up to life it would go.
Mind you, yes, they do. It's a discharge of a firearm causing death or great bodily harm. This man was shot twice in the abdomen and could have died.
But the jury found him guilty of what would be classified as a second-degree felony, which under the laws of the state would have given him a maximum of 15 years. So, we haven't looked at the underlying facts to understand, how horrible the facts were, but the jury somehow didn't think it was as, horrible. And what we're not really talking about is how bad the crime is, but whether there is any restriction on the judge's sentencing to up to life when there's a statutory maximum of 30 years.
The legislature intended for it to be this way based upon the enactment of this statute.
I know, well, that's really what, if it were clear, I don't know there would be a conflict and I wouldn't be asking these questions. You look at me in this amused way as if there's no way to read this statute in two different possible ways. And I'm in good conscience telling you I read that next subsection and I get confused as to what the meaning of it is.
I apologize, Your Honor. Bemusement aside, our position is that if it's construed in the way petitioner perceives it to be, then there can never be a life sentence for a first-degree felony. And it's a 25 to life provision under that specific provision that provides for it. I think that construction is illogical based upon the plain language of the separate subsections in this statute. And that's our position, that it's not capped at 30 years.
Wouldn't it be just so easy if the legislature took 775.082 and said that the statutory maximum is 30 years. However, if a defendant discharges a firearm and causes great bodily harm, the statutory maximum can be life in prison. I mean, wouldn't that just solve the problem?
Arguably. It's our position, though, that the way the statute's written, it does provide for 25 to life within that range when these instances occur.
But, we've been talking in terms of that, if you read it the way the appellant says, that you would rule out the possibility of a life sentence. But that's a life mandatory minimum.
Correct.
But that's not necessarily true, because if you're convicted of a first-degree felony, under this statute, can't you enhance that to a life felony? And then, of course, you could certainly, it seems to me, impose the mandatory life sentence. Isn't that a part of this statute, too? That you can enhance from a first-degree felony to a life felony?
For the use of in subsection 1.
Okay.
Our position is that when you read 1 and 2, that subsection 2 is the more specific provision.
Okay, but I'm simply saying, if the defendant is convicted of a first-degree felony,
okay,
and then we turn to 775.087, we enhance that to a life felony.
Okay.
Certainly, under those circumstances, the court could properly give the defendant, assuming it's some kind of discharge of a firearm with serious bodily injury, could give the defendant a mandatory minimum life sentence. He could make that life sentence a minimum of life. Isn't that correct?
I believe so. Okay. I do think, though, that the specific controls over the general. This is a general, subsection 1 has been there for a long time, and then they created subsection 2 to create a more specific scheme.
But whether it's a general or not, under those circumstances, you could, in fact, impose a minimum life sentence.
Yes, you could, okay. But the 1020 life, the more specific sentencing provision would apply there because it meets all of the parameters of that specific sentencing scheme.
I'm really just trying to see if there is any room for operation of the 25 to life. And so the to life can, in fact, be imposed if you have enhanced the sentence, the crime to a life felony.
Correct.
Okay.
But I reiterate, our position is that with that second subsection, provided you have the enumerated felony, that 1020 life would be that the trial judge would have to apply.
Yeah, I understand you. I'm just trying to get it straight in my mind. If it's still any room for operation for that enhancement to a mandatory minimum life.
Okay. I just want to reiterate, I think that the 50 CA looked at the statute in its entirety correctly and applied the correct range. And I do think that by capping it at 30 years, it erodes the stated intent of the statute. I think the language is plain and that the legislative intent with a specific subsection D in it providing for it demonstrates what the legislature intends for these specific offenses under these specific type of facts, that they be punished to the fullest extent of the law. And there was no intention based upon that phrase, which is in the statute, that it be capped at 30 years. It's a 20 life provision. And it's our position that the language is clear.
Except they say, after they say the fullest extent of the law and the minimum term of imprisonment imposed shall be imposed. They say that in the conjunctive. That's why I keep on going back to that the issue is that they clearly intended there to be harsher mandatory minimums.
Correct.
We're only really talking about whether the statutory maximum is of an individual statute is trumped by the 1020 life, and that's where I still have some questions, because they certainly would know to say to be punished to the fullest extent of the law, and that the minimum terms of imprisonment and the statutory maximum be governed by this statute. That's, again, another way that they could have done it. And keep on, they're referring to mandatory minimum is a term that we all understand refers to the minimum sentence, and you've, I think, agreed that the judge doesn't have to impose a mandatory minimum of life even for discharge of a firearm, correct?
And serious bodily injury and death.
They're not compelled to impose a mandatory minimum of life.
No, it's a 25-year. He has to impose a 25-year minimum mandatory. At least, but the range is up to life. We asked this court to look at the FDCA's analysis where they went through the statute, as opposed to the cases that are in conflict where there's very little rationale to the conclusion in Wilson and Sousa and even Collazo. And I think the Fifth does the correct analysis under the statute when you consider the bases for which this statute was enacted, which this court did a nice job, but did look at in McDonald. And I think McDonald's elucidates this notion of specific over general when read in conjunction with the legislative intent of the statute. And it's our position that in reversing the order granting the Rule 3800B, that the 35-year sentence is proper and lawful under the 1020 life provision, that the opinion of the 5th District Court of Appeals should be approved by this court. Unless this court has any other additional questions, I appreciate it. Thank you.
Thank you. Any rebuttal, Ms. Collins?
While the respondent has argued that this was a more specific and unique scheme, the legislature themselves have included within this text of this statute the reference to 775.082. Had they intended this to be a completely separate sentencing scheme, they could have left out any reference to the other statutory maximum. Also,
well, but even there, we were talking about felonies first degree. That statute recognizes that there are circumstances where a term of life imprisonment may be imposed for the first degree felony when specifically provided by statute. So arguably, maybe more than arguably, maybe clearly, this statute is one such circumstance where there's a specific statutory authorization for the life sentence that's given. That may be given in the discretion of the trial court.
I would argue that the Section 2C, however, is a limiting on the minimum sentences, and that's where the statute is ambiguous. Also, the decisions from Sousa and Yasin holding that there are statute maximums that the mandatory minimums are subject to the statutory maximums have been out since 2005. And had the legislature wished to correct this interpretation of the statute, they have had full opportunity to do so.
They've been busy.
And if there's no further questions, I ask you reverse the 5th District Court.
Thank you. Thank you both for your arguments. The court will now be in recess until tomorrow morning.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.